First of all, I would like to thank Philip Cole, the conference chairman, for inviting me to moderate this session. I find the presentations so far by the speakers are really interesting, and I find the topic really fun. Before I start and open to the floor for questions, I must review that when Philip first invited me, extended his invitation to me to moderate this session, I was at first very hesitant because I only have very limited knowledge on sanctions arbitration. The law on sanctions that I'm familiar with only relates to those sanctions imposed upon me by my wife. But but the issue of arbitrability relating to those sanctions is moot because there will always be one outcome. Yeah. You will never see any light at the end of the tunnel. But first, really, thanks a lot, Dr. Yarik and Dr. Patricia. We are honored to have you today to have a very comprehensive, which gave us a really good insight on arbitrations and sanctions. There was I had a question before Patricia's presentation, and that was that when we decide the issue of arbitrability, do we also take into account the issue of enforcement? If it actually concerns with public policy, should we kill it off at the start? But after hearing Dr. Patricia, there are actually other reasons why we should not do that. Because you could actually enforce the award in other countries against the loser of the arbitration where the loser has assets, right? Before I really open up to the floor for questions, I would like to give the first opportunity to the speakers on the first panel to ask questions of the speakers for the second session. Benjamin, do you have any question?
Thank you. Well, first, thanks to both of you for those very interesting presentations. Just to be clear, Patricia, my point about considering the severity of the sanctions on the non-performing party is not at all a jurisdictional or arbitrability issue. The tribunal should decide, as a court would decide, whether the non-performance may fall within the scope of the sanction, of course. And I would go even a step further in favor of arbitrability. I mean, I endorse everything that you said. Even if it falls within the scope of the sanction, that does not mean that party wins. Because you have to do now, I think there's a very delicate balancing test to be considered here. You have an innocent party who is a party to a contract that's not being performed, and you have another party that is not performing because of the sanctions. There's no justice in this world. So, I'll put that as a question to you. What do you do in that circumstance? You've got essentially two innocent parties, only one of whom may be suffering a loss as a result of a sanction that neither party intended or contemplated.
Well, since I was a common law lawyer before I became a Swedish academic, I can say that and I'll throw the question back to you and to all of you. Do you think that you could perhaps use equitable remedies and say that perhaps restitution could be used, or could you use estoppel? Could you try to find? I mean, obviously arbitrators are not allowed to act as some kind of amicable compositor without a specific request of the parties to do so. They'd be going beyond their mandate. But could they use other potential legal remedies?
I wouldn't say estoppel would apply because there's no behavior that you could attribute to that party by which they would be estopped from making a claim. So I don't know. I mean, it's a tough situation. for the parties to be in. And I think in circumstances like that, the tribunal may have to come to the parties and say, here's the situation we find ourselves in. But it seems to me at the end of the day, some balancing test would be in order. If one party is going to be executed if they perform this contract, I don't think there's any way you can really hold them responsible for non-performance. But I think there are. This is why, as I said earlier, this is why it's so pernicious for these sanctions to be intruding into private commercial relationships where, as you and I think agree, they just don't belong.
And if you look at the Swiss approach on one of the cases that you mentioned, and that involved bribery, a claim that the contract was actually for paying bribes, and the tribunal looked at it and said that, according to the tribunal, that a typical fee for representing and getting the contract would be 10%. And so that since the amount was more than that, so they said, well, when the amount goes over that, there's a red flag. So that the tribunal said, we're going to limit recovery on this representation. And they said it didn't violate the trade sanctions because it was contingent on the sanctioning being, at the time of the performance, that the sanction wasn't in place anyway, getting into the details. But they fashioned this reduction under the contract, and the Swiss court seemed to say that that was very strange ruling of the tribunal, but because of the strong pro-arbitration, they didn't set it aside on that ground. But as an arbitrator, I would feel very unmandated to start adjusting the contract terms to what I thought was a fair outcome. I would feel that that would be inappropriate. Yeah, the parties expressly. Mediation might be a good solution.
Yes, Alistair.
I think this is a great question from Ben. Where's the fairness in this? Who's going to bear the cost? What it does, I think, is remind us that this is not just a legal situation. As lawyers, we tend to look at a contract, we look at a dispute, but actually in the commercial context here, for example, it's quite likely that somebody will have political risk insurance for which they've paid, and actually that's where the loss may end up lying. But as lawyers and arbitrators, I would suggest it's not our business, and I think this was your point, it's not our business to be looking at redistributive justice generally. We apply the law, we apply the contract, and then it's for the parties to lay off that risk through insurance or whatever other way they think is appropriate.
Could I add a comment? Well, coming from a common law tradition, I recollect my master's studies when the first case came out, BP and Hunt, restitution book written by Govan Jones, right? Essentially, when the frustration contract, there's a frustration, then you're going into the Law Reform Frustration Contracts Act, which is replicated for those of in Malaysia, the Civil Law Act. If you don't know that, there's some section there that replicate that. So you have a kind of in common law, the act falls, the laws will fall, and you follow the law. But the disquiet caused by frustration has birthed this legislation where unjust enrichment issue, restitution comes in. I think we are steering within these waters, but you must have specific mandates to do that. You can't just pluck a common law or equity to do that kind of justice, all right? Just as the IRS example you gave, then I remind myself of Hoffman J., the great civil law who became a House of Lords Charterhouse and Investment Trust. Then they'll say, look, in companies that try to do tax savings and you may be considered tax evasion, there's nothing illegal about that. You don't strike a contract out for illegality merely because there's a whiff of illegality, right? You try and steer between the skylar and the cherubdis of law and all these adjustments while keeping your analytical clarity. And you must have a justification in arguing that. It must be based on a principle. It's not something you pluck out the air as in the chancellor's foot of an equity chamber, right?
Yes, you have a view? Yes, okay. You have a question.
Yeah. Oh, thank you. Thank you for your great presentations. Well, I've got two questions. The first question is, we all agree about the separability doctrine and the way that even if the contract is not valid or there is a problem with the contract, as long as we have a valid arbitration agreement, we can go to arbitration. But what if the party under the sanction cannot pay the arbitration cost in order to initiate arbitration? And the second question, what if the arbitration center rejects to file arbitration because the party requesting the arbitration is under sanction? I'm not talking about an exotic center. I mean, I'm talking about ICC, which in the last 2 years rejected to file Iranian cases in a very unprofessional way. I mean, even it didn't reject explicitly, what it did was just saying it's under consideration and it's under the process. So, I mean, I have a case more than 1 year just waiting, and every week we are writing a letter to ICC and they say, it's under process. We are considering the case to see how it can be managed. So is there a liability for the arbitration center? And if it does not file the case, no, seriously, if it does not file the case, what can we do? I mean, in such situation. Yeah.
And statutes of limitations running.
Yeah, it's a difficult question, and fortunately, most of those questions, well, for most institutions, they are more theoretical, so there are very few cases where I actually have to deal with this. I asked a similar question to a representative of LCIA in London a few weeks ago, and she said, well, we haven't had any practice on it, so I cannot really comment, and it will depend on the language of the sanctions, on the language of the arbitration clause, and so on. And yeah, justice delayed is often justice denied, and well, the usual route would be probably to seek a license, right, for the arbitration institution to engage in these sort of transactions. And I remember when I was still working in the United States, we worked for an investor which had a dispute in federal courts with Iran. And it just delayed tremendously the proceedings. So the case lasted for like almost 30 years. 30 years. Well, it's good for the law firm from the point of view of ours, but it's certainly not good for the parties, because they lose a lot of money and there's not much they can do, because the arbitral institutions or other entities subject to U.S. jurisdiction are afraid of sanctions. And we talked about this case against Paribas, $9 billion fine. So would you rather be super cautious and wait for even 20 years before you actually reach the final decision, or would you rush and say, okay, well, I understand you're in a rush, so let's just deal with it, and we'll deal with the consequences later. So it's a difficult question, and it hasn't been explored properly yet.
On a related note, for the KRCA, the liability of the arbitration institution, we have an act to protect the director and also the officers of the KRCA. They are actually immune from liability in relation to the performance of their duties that's related to KRCA, including the management of arbitration cases. And the immunity accorded to Professor Dato Sundra as the director of the KRCA is the same as that accorded to a diplomat. Yeah.
Just to complete my comment, I mean, at the beginning, the excuse was, the ICC excuse was, we cannot accept the money coming from Iran. Later, we had an arbitration in ICC, a European company and Iranian company, and the arbitration was going. In the middle of the arbitration, the Iranian party wanted to counterclaim, and the ICC didn't file a counterclaim. The arbitrator did not accept it because they said you cannot pay for the counterclaim. The Iranian party found a solution. Since the European company was the contractor of Iranian company in Iran, it said, okay, Iranian company said we pay the amount to our contractor in Iran, and he can pay our share in arbitration. And still ICC rejected to accept it. And so I'm saying it's a very frustrating situation.
Yes, I think, yeah, if there are actually no, sorry, Benjamin. Yes.
To echo that, I mean, it's just so completely unfair. I mean, these are private commercial parties. And you see that in this, structurally, I have a case where a sanctioned party is the respondent, and the claimant pays the full fees, and they go forward, and they can enforce that award somewhere else. But if you turn it around and the sanctioned party is the claimant, they can't proceed with their claim. And now, even on a counterclaim, when they're, so I mean, it's just up to the point of being absurd. You have my sympathy, sir.
Anyone else who wants to comment on the issue? Oh, Alistair? That's right.
Thanks. Sorry, I'm not proposing to be a serial commentator, but I can think of a solution to the situation, even though it's not really a solution. It seems to me that in those situations there'd be a reasonable argument that the arbitration agreement is inoperative or incapable of being performed, and therefore might actually fall away, or at least you could make the argument. The problem with that, of course, is that it then leaves you without an effective remedy in an international situation, because all you've got is going to a national court, which may not actually be able to yield a useful result. So I just offer that as a comment, as a way to take the situation forward, but it may not take you forward to a place you want to get to.
Thank you, Alistair. Perhaps another solution would be to have it publicized. Made it known to the world that this is happening in the ICC court.
What about voucher funding? What about voucher funding?
Voucher funding.
They don't explicitly reject it. I mean, they just say we are considering the case. So I'm saying I myself have a case that was 1.5 years just waiting to their consideration and come to a conclusion.
I see. But the outright rejection might not be as sinful as, a delay, the tactics being practiced by the ICC court. Yes, Faris.
We actually had an inquiry from a Saudi Arabian party that was attempting to bring a claim against Egypt under the Organization of Islamic Cooperation. And essentially the same thing happened. The secretary, when a request was made for an arbitrator to be appointed, just sort of sat on their hands and wouldn't touch it. Didn't say anything, so didn't say no. So nothing was triggered in that respect, but just wouldn't do anything with it. And what we ended up sort of doing together with the Saudi Arabian party, we figured out that they could actually, through the MFN clause that is in the OIC, they took advantage of the Egypt-Sri Lanka bit, which actually has in it a clause, a reference to KLRCA, of all places. So, in effect, the Saudi Arabian party is now able to use the MFN clause to bring their claim here. I think they're still in negotiation stages at the moment, so I'm not sure whether that will be registered or not. But this fear of political influence, I mean, and that's not even a sanction, that's just sort of indirect influences that are affecting it, appear everywhere.
Thanks. Thank you, Faris. The two speakers on the first panel have already asked their questions. I think now I can say it's officially open to the floor to ask questions. Anyone? Just raise your hand. Lauda, you have any question? No? Anqua, you have any question? No? Yes, Faris.
Do we look scary?
So I do have a question as well, actually. This morning as well as this afternoon, we've been talking about mandatory law and looking at the character of the mandatory provisions depending on what kind of mandatory provisions they are. I mean, we discussed banking and finance regulations, and I think we spoke about that yesterday as well in the context of Malaysia and the Central Banking Act. And I think Ben posed an interesting question. I'm not asking for an answer; it's quite a difficult question. But what happens when two parties who are not from the UK are using English law, for example? Are the mandatory laws under English law applicable to those parties who are not actually resident in the UK? What tools and factors can we use to actually interpret the mandatory provisions to try to be able to actually ascertain what the effect of them will be?
I think, if I understand your question, I think that one of the first issues is going to be, let's say if we have English law, and then you say, is the trade sanctions mandatory part of the English law? And then is it something which rises to that level of public policy that becomes mandatory? And then, of course, if it's mandatory, as was already said, it can't be contracted out of. But one can maybe ask, does that mandatory law come into play? And that's a question that's not really decisive. You can say, in the first hand, if we go back to the idea of contract, that you look for the rights and remedies and obligations in the contract, and then you say, does the contract, in its risks assessment, in what the parties have contracted to do we find the solution to the problem there? And then we go, usually the applicable law is a backup so that if there's a gap, then you go to the applicable law. But if you could say that the contract, there is no gap, the contract, the parties have agreed. Do we need then to go into the, you might say, backup of the applicable law? Because the English laws only apply because the parties say that English law will apply, but in the first hand you look at the contract. Then could you get around, what do you think? Does it become mandatory that you have to go there?
Yes, a contract is one way to understand the situation. The other way is to look at the act itself. So maybe it only applies to residents. Maybe it only applies to institutions, which are subject to certain UK regulations, and very often it only applies to residents or to those who have license of a particular financial institution in the UK. So, looking at the language of the contract, looking at the language of the arbitration clause, looking at the language of this Sanctions Act in whatever form it comes, I think, I think this is the answer, because otherwise it's difficult to give an abstract answer saying, well, yes, it does apply or it doesn't.
But one of the concerns I have that I questioned in the morning session is that when you have sophisticated parties, large companies that have sophisticated in-house counsel and outside advice, they do a lot of precautionary, preventive. They're planning around it. But if you end up with a lot of the businesses, a lot of the stuff that's driving the economic engines and hopefully the progress and recovery, these are traders that maybe are just using standard form trading contracts. Maybe they have on a website their general terms and conditions, and they're not getting this kind of complex advice and then end up in the situation. And they're the ones who can really get caught in the disadvantage, and are also the ones who probably financially are at risk that they're not able to fund these very expensive advice, the long delays, the rerouting of banking. So it really seems, on top of what you say, the unfairness, the parties who get trapped are going to be the SMEs.
Yeah. And when it comes to English law, so the worst thing which may happen to you is that you will have to go to English courts, and then known to have a certain reputation. So probably they will not be particularly unfair. So if you end up with litigation in England rather than with arbitration somewhere, probably it's not the worst outcome.
But how would you, if you had a contract involving a Russian respondent, and then the tribunal dismisses it, says this is non-arbitrable, how do you end up in the English court?
Well, it depends on the language of the act. So if the act says that no transactions whatsoever are possible, then it's one situation. But very often the language of the sanctions is not that harsh. So I think the Iranian sanctions are much more harsh than the Russian sanctions, because the Russian sanctions, in most cases, they only limited the ability of companies to raise money for, I can't remember, for more than periods more than 3 months or something like that. So it's not a complete ban on doing any business. So I think with Russian companies, it shouldn't be that bad. So you can go to arbitration. It's possible to make sanctions. If it's an Iranian company, then it can be more difficult because, as I showed you, the language of Iranian sanctions is much more tough.
A related question. When determining the issue of arbitrability by the tribunal, do you think that the seat of the arbitration chosen by the parties would be a relevant consideration?
Yeah, I think it's one of the most important issues is to decide on the seat, because the arbitrability of the issues in the first place will be challenged in the seat of arbitration, right? And so if the seat says that no, you can't have any dealings with the particular company, then basically you don't have arbitration, you don't have an award. So it's, if you are lucky at the stage in the seat of arbitration, then you may be unlucky in one jurisdiction, but you can go into another jurisdiction that you just have to enforce your award.
Yeah, I can mention that Sweden, like Austria, I don't know if there's many jurisdictions that have this, have in the statute that you have the right to review a negative jurisdiction decision of the tribunal in the court. Now, it's a very interesting debate whether or not you have that implicitly in the model law and other jurisdictions, but nonetheless, we did have a case some years ago involving a law that no longer exists, the soil and resource law of Russia. And so in a case was on a Canadian company that had a contract to do exploration and mining of diamonds in a diamond field, and then that was canceled, and it was given to, and the contract was given to a Russian oligarch instead, and they brought arbitration proceedings in Stockholm, and the tribunal in a 2-to-1 decision with a great dissent I can recommend reading on arbitrability, authored by Jeffrey Harsfeld. The tribunal, the chair I think was Sergei Lebedev, dismissed the case for arbitrability, saying this is against Russian law to arbitrate natural resource mining, and it clearly was. No issue, it clearly was, but when it went to the Swedish court said, it's perfectly arbitrable here. Everything is arbitrable in Sweden, practically. So the tribunal was wrong in dismissing it, so you can go ahead and get a new tribunal and get going again. So for that case now is about 9-10 years old. So we have precedent that I think that it would be unlikely in a Swedish arbitration that a dismissal under the trade sanctions would get traction in a court. The merits of the case and the decision might get some traction, but I think a dismissal and arbitrability in Sweden would be questionable.
Yeah. Thank you, Patricia. I think following from that, the audience also would like to know whether the High Court has a jurisdiction in Malaysia to review negative decision on jurisdiction. There is a case by the High Court. The presiding judge was Justice Mary Lim. She said that by way of obiter, in that particular case, that the court has the jurisdiction not only to review jurisdictional decision, which is positive in nature, but also negative in nature. Because in the Ancestral Model Law, which the Malaysian Arbitration Act adopted, only says if the arbitrator decides that he has the jurisdiction, anyone who is challenging that decision has a certain timeline for them to refer it to the High Court to review the decision of the tribunal, but it does not say whether the High Court has the jurisdiction to review the decision if the tribunal says that I do not have the jurisdiction to proceed with the arbitration. So now we have a High Court decision by way of obiter saying that the High Court has the jurisdiction to review negative jurisdictional decision by the tribunal. But unfortunately, the case, when it went up to the Court of Appeal, it was reversed, but it was reversed on other grounds and not that particular issue. So maybe I think it's still very much alive. Thank you very much. Any other question? Yes.
I was just thinking out loud, and based on the discussions, what about if we have an arbitration litigation clause where we say that, of course, any dispute that arises out of this contract will be subject to the ICC, QLRSA rules of arbitration. Failing that, for example, the arbitration institution to accept jurisdiction, it will go to the Court of England and what do you think something like that will work?
So that the clause would say that you arbitrate, but should the case be dismissed for arbitrability, you then would have a forum selection clause.
Yeah.
I guess party autonomy? I always get a little bit worried, though, when parties start mixing a lot of different clauses into a contract. I'm actually working on an article on that. They're creating not a toolbox, but a Pandora's box.
Have you ever come across anything like that, where they have arbitration litigation?
No, I haven't seen. I have come across pathological clauses saying that the parties can arbitrate or litigate, and obviously that wouldn't work because there needs to be a decision to either to arbitrate or to litigate. However, if there is a decision to arbitrate in in one part of the dispute resolution clause, and the next one is saying failure, I don't see any reason why it shouldn't work.
And this will save the problems that you are facing now, because you could go to the English courts and they can deal with the subject, providing that you provide that the center is not dealing with the issues or they're refusing taking the jurisdictions.
Provided that English courts don't have to follow Iran sanctions. So that's
Well,
another problem.
But then they have to deal with that issue.
Yeah, but I think the problem with the institutes are that the institutes are concerned that they're providing a service. And under French law, where the ICC is sitting, French court decisions have clearly, for example, the SNF case on the Du Haste a few years ago, make it quite clear that the ICC is providing a contractual service. And so under French law, they are a service contractor. And since they're sitting in a EU country, they may be concerned that they would fall as a party to the sanctions, whereas I don't think a court could be considered to fall under the sanctioned activity. I would think a court would be immune. I mean, the court would have to apply the sanction law, but the court itself would not be getting paid as a party providing services to a targeted party.
I agree as well. I think if we think of the universal rights law or related law, everyone should be given the right to have his grievances determined through a forum.
The arbitration clause is frustrated. I mean, it doesn't work out. I mean, we have a valid arbitration agreement. If you go to the court, we have a valid arbitration agreement. If you go to the court, it's very reasonable that court says you have a valid arbitration agreement. And as far as I understand, when an arbitration institution publishes its rules and gives the model law and model clause at the beginning of the rules, indeed, it is giving its offer to public, its offer. And when I put the arbitration clause in my contract, the model clause in my contract, indeed, I'm accepting that offer. So a contract is already made. And as far
and the SNF decision would agree with you, but I guess the ICC might take your morning session and say that the ICC might say we have an impediment.
Yeah.
No, but you're quite right that the French court has clearly said that it's based in contract, and that's why a complete exclusion of liability is not possible under contract law.
Just to answer you, and they may interpret that their clause that it's not basically an offer. They may tell you it's an invitation for you to offer us to come to us, and then we accept. So it's yeah.
Any other questions? No? All right, I think then it's time for a break. Thanks a lot. Thank you very much.
Thank you.
Yes.